I want to talk about a concept called vicarious liability. And vicarious liability is a principle that holds the employer responsible for the conduct of its employees in civil proceedings. So let's suppose there is a situation where a woman was sexually harassed at work and you're suing civilly and you want to sue the employer as responsible for the conduct of its employee. So the argument of vicarious liability means that the employer is responsible for the conduct of its employees without having to show negligence of the employer. That's what strict means. So strict means no matter what happens, the employer is accountable and responsible for the conduct of its employees. Unfortunately, this is a very difficult concept to prove because the law is that you must show that the risk of the injury that's happened is closely and materially related to the employer's business. The example I'd like to give is you go to Starbucks, and when the employee is pouring you a cup of coffee, you reach your hand out to receive it, and accidentally the coffee spills on your hand and injures you. Now that's conduct that I would expect is closely and intimately related to the risk of the business. That makes the employer responsible. However, if the employee threw the coffee in your face, then the employer very unlikely would be responsible because it just isn't normal and rational to expect that's the type of risk that's clearly and closely related to the business enterprise of the company. The cases involving sexual misconduct in which vicarious liability has been applied usually involve things like group homes or the Roman Catholics churches that looked after children in the Indian reservations that the children were taken from Indian homes and sexually abused. Then it has been determined that that's the type of risk that's closely and materially related to the business. Now, that means strict liability again. That doesn't mean the employer can't be sued, but to sue the employer on other arguments, you need to show negligence. For example, if the employer hired someone who was a sexual predator and hadn't done personal reference checks and hadn't looked into the background of the person, or the person had sexually assaulted 3 other people before this, so there's been a visible example that this person's a risk and the employer did nothing. That means showing negligence on the part of the employer, which is a different test. So again, vicarious liability, closely and materially related to the risks of the business. Strict liability, then, don't show negligence, or prove negligence based on the context of the case to hold the employer responsible. So you're always looking for some pockets. So in this situation, if somebody is seriously, particularly sexually abused, to use that as an example, it doesn't have to be related just to that. You either have to show strict liability or negligence.